I take all the points, and I just have to say, it sounds like either A, everyone in your household was sick like 2 weeks ago and you're really focused on it, and B, that you've got like an illicit stockpiling and straw purchase Sudafed ring going on in your house, and I'm really concerned.
I'd love to say if you want Sudafed, come to our house. But
no,
the thing
literally
is,
don't say that.
We barely have any around because we use it all.
Okay, so I take both of your points.
Can the government steal babies' blood? We'll find out when we discuss a case from the Sixth Circuit that addressed that question. Also, out in the Ninth Circuit, there was a unicorn sighting. The circuit actually found a gun control law unconstitutional. All that this week here on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Tuesday, July 1st, 2025. I have two of my esteemed colleagues here today to discuss these earth-shattering cases of interest. First, though, I have a quick announcement. As we discussed on last week's show, we are coming to Chicago for a Short Circuit Live. So if you are in the Chicago area and you would like to see us in person, we have a show on the evening of Sunday, August 17th. It's at the Swiss Hotel in the Geneva Room in downtown Chicago, and it is on the eve of the 7th Circuit Judicial Conference that will also be attending. So I will be hosting that show, and on the panel will be my colleague, and that is John Wrench, the Assistant Director of the Center for Judicial Engagement. So John also happens to be on the show here today. So John, welcome back to Short Circuit. Anything more you want to tell the folks about our show in Chicago?
Well, thanks, Anthony. Yeah, I think it's going to be a ton of fun. It'll be great to be in Chicago. And I think it will be kind of a nice way to lead into the conference for people. So I hope that they come by and they hear a live Short Circuit recording, which is always a ton of fun to actually be there in person.
That's right. And it won't be this one, but a ton of fun will be had at a future Short Circuit Live with Will Aronin, who is a senior attorney here at IJ. And I say Will be on a future Short Circuit Live because he just threatened me and said he has not been in one in the past. And so we're going to make sure that happens to keep the peace. So Will, welcome to Short Circuit, and welcome to your future appearance.
Thanks so much for having me. And in fairness, I don't think it was as much a threat as like implying like New York style guilt.
Aren't those the same thing, though, basically?
No. One is, look, it'd be terrible if you didn't invite me. The other is, sure, just don't invite me. I understand. You don't want to be near me. I get it.
Gotcha. Well, I don't know how that segues into gun control, but
that would be the threat.
Yeah, I mean, that all kind of runs together. So we have this case out in the Ninth Circuit. So the Ninth Circuit, the Ninth Circuit has a reputation. Although it's not quite as kind of progressive as it used to be, it still is fairly that way. And at times in the past, it has not really wanted to go along with what the Supreme Court has said about the Second Amendment. But on this particular occasion, it seems it went with the flow. Or is it with the flow these days, considering how Second Amendment law keeps changing? So Will, tell us about Nguyen versus Bonta and this rule I actually forgot about in California that you can only buy one gun a month.
Thanks so much for having me. I have the absolute very rare privilege of talking about a Ninth Circuit case that struck down a restriction for violating the Second Amendment. And as Anthony, as you said, this is Nguyen v. Bonta, and it talks about a 30-day restriction. So you can only buy one firearm, doesn't matter what kind, once every 30 days. And the purpose that California said, like the reason they passed the law was an attempt to prevent like mass purchases, like essentially arms trading and straw purchasers. But ultimately, what it was doing was limiting the rights of law-abiding citizens to purchase like normal firearms. So the Ninth Circuit the panel went through and talked about the analysis, and it tried to determine like how do you find out if a law restricts or violates the Second Amendment. And there's a two-step analysis after the Supreme Court in Bruin and Rahimi. Number one, does the restriction violate the plain text of the Second Amendment? And number two, if so, then that restriction is presumptively unconstitutional unless it is similar or analogous to our text, history, and tradition, or an analog that the founding generation would have passed. So a similar type of law, though it doesn't have to be one-to-one. So going through that analysis, first we see that the Second Amendment, as some of our viewers know, protects the right to keep and bear arms. And as Heller talked about, that is the individual right to possess and to carry weapons. There's nothing in the text of the amendment itself that restricts the number or limits you to just one weapon, and all the relevant case law from the Supreme Court on down has talked about this being a plural right, an individual's right to have several weapons. The panel then found that the restriction basically violated the plain text, and it didn't credit California's two arguments. The first argument was just facially that the actual amendment doesn't cover the right to have multiple firearms. I guess in California's view, you get to have one weapon.
I mean,
and the court,
it does say arms, right?
Keep and
Isn't that
bear
pretty
arm.
obvious?
You get to have one, keep and bear arm. So honestly, the panel gave pretty short shrift to it. It's atextual. It doesn't fit. The history doesn't support it. But it did talk about the idea that a delay in and of itself is not facially violative of the Second Amendment. And it had some arguments that I do want to give some credit to. For example, it cited a Fifth Circuit case where a background check results in a 10-day waiting period, or it could take up to 10 days before you're able to purchase the firearm. And that was not in and of itself unconstitutional, even though it did result in delay. And the panel, I thought, quite reasonably said that the background check itself may be reasonable because there is a good or a reasonable purpose behind it. The goal is to make sure that unusually dangerous people do not get firearms. Here in California, on the other hand, the goal was the delay. The process was the punishment, in other words. And really, this was just designed to make people wait. So there was a quote that the panel did that I thought was really, really helpful, and I actually wanted to cite it because this is a little reductive, but going to the glasses, as Tony Kornheiser says, this is, I think, a very useful analysis by analogizing it to other rights. And the panel said, we doubt anyone would think that government could limit the citizens' free speech rights to one protest a month, their free exercise right to one worship per month, or their right to be free from unreasonable searches and seizures to only one search or arrest per month.
You know what I thought when I heard this? Sorry to interrupt, Will. I thought about how I can only buy Sudafed once a month. And I do have a right to purchase pharmaceuticals that help my allergies or my cold symptoms. So anyway, maybe we could circle back to how
that
it
in
might
the Ninth
apply there
Amendment?
later.
It's in the penumbra. No, the right to keep free and clear nostrils.
Mm-hmm.
So I know it's a little reductive, but I do actually think analogizing one right to another is helpful, and I do think it's a useful way of considering the right. Like, take the right that anyone cares about or that you care about most in the Constitution, consider whether a restriction on that would apply, and then apply that same logic to the right you care the least about. And if everyone did that, I think we'd be in a better place. So the court rejected it, said that delay on and of itself is not okay. That the 30-day restriction does violate the plain text, which moved them along to step two, which is really kind of the key of Second Amendment analysis now, the text, history, and tradition. So once we know keep and bear arms, it's covered by the text, we then consider whether or not there are analogous laws from the founding generations, and I say generations because they could be at the actual founding in the late 18th century or post 14th Amendment in the 19th century, and to consider whether or not our history, whether or not there were other laws that similarly restricted individuals' rights to solve similar problems. And this is where the real litigation of the Second Amendment. This is where it comes to a head, because the fight is how high of a level of generality do you go? If the idea is you can, our history allows you to restrict dangerous weapons, then that basically justifies any restriction. If, on the other hand, you literally need a one-to-one law, then honestly, you can't solve anything that wasn't solved in, let's just call it 1880. So the fight is on the level of generality. And I actually thought that this panel went through and did a very good job of somewhat briefly summarizing where our history applies. And it talked about the types of laws at the two foundings that existed. And some of them, for example, were laws limiting sales to intoxicated persons. Some maintain that there was, at least in 1881 and 1882, laws that require firearms dealers to register and track sales, so some sort of a background or a registration requirement. There were taxes. And then there are the two that I think really make up the key of the Second Amendment analysis, which is limiting the sale of weapons to people that were thought to be unusually dangerous in our, frankly, somewhat racist history. The laws that were relevant here were laws that limit the sale to Native Americans, or laws banning or restricting the purchase and the owning of what were thought at that point to be unusually dangerous weapons. So in Georgia, dirks, sword canes, spears, and some limits on pistols, they were barred. Essentially, they were like hidden concealed weapons. And then in Tennessee in 1838, there were restrictions on Bowie knives. And ultimately what it determined was these were restrictions that could apply. Or taking one step back, it reviewed the history and it said, we need to look at what was the problem that both the founding generation and California was trying to solve. And in this case, it was straw purchasers. And while straw purchasers was somewhat of a problem there, they analogized it to arms dealing. And they said that there were absolutely laws on selling to Native Americans, selling to rebellions, just arms trafficking in general, but that the solution that the founding generation came to was not restricting the amount that a law-abiding person can buy. Instead, it was to actually criminalize the arms trafficking, which is largely what right. The concurrence came down with.
Which there are laws that do that already in California.
That's basically
in federal
it.
Law or
and because the founding generation had seen this problem, didn't try to restrict it by limiting the rights of law-abiding citizens at that point. They tried to actually criminalize the criminal conduct. It doesn't pass our text history and tradition. And I want to credit David French on advisory opinions because I've heard him talk about the Second Amendment a lot. And I think where he comes down is probably a really good place, which is our future litigation is going to come down to two things. Is the weapon itself unusually dangerous? And then we have to evaluate what does that mean. And that we're seeing that with magazine restrictions. We're seeing that with assault rifles. And on restrictions of people who themselves are unusually dangerous, whether it's felons, people with red flag laws, whether it's people with domestic violence. And that's probably going to be where the Second Amendment focus is going forward. What does it mean to be particularly dangerous, either as an individual or for the weapon itself? And the concurrence here is unbelievably short. It is one paragraph, and it just says, I guess I'm going to paraphrase it because it's not literally in front of me, but there's nothing in our opinion that says you can't actually deal with straw purchases or bulk sales, which I think is 100% right. Criminalize the criminal conduct. Go after people who are breaking the law, who are using the weapons in an unlawful way, who are buying a weapon just to transfer it to someone who does not themselves have a legal right to purchase it. Criminalize the bad actors. Don't go after law-abiding citizens. And I really want to say I have the rare privilege of saying that the Ninth Circuit panel got it right in this case.
Yeah, and that concurrence is 3 sentences. I mean, that'd be great.
I said it in one.
If we could have well, it's one paragraph, 3 sentences, and it would be great if we could have more concurrences like that. I must say, John, you have a similar take on this unicorn.
Yeah, no, I do think that it is a pretty solid analysis. I think that the one thing that I would have liked to see hashed out, though I think that this is probably the kind of thing that would be hashed out in a future case, is, like Will was saying, it does seem like this is going to come down to questions about whether there's a uniquely dangerous weapon, a uniquely dangerous person, and that you have maybe the government develops methodologies for identifying both of those things. I think you could make the argument, if you were the government trying to defend a similar kind of law in another case, I think you would make the argument that the ban on more than one gun in 30 days is kind of a stand-in to get to those actual concerns. It's like an inference about it. And I think that that's what you would argue, is the stockpiling and accumulation of weapons within a 30-month period is a combination of weapons that on its own kind of becomes something more dangerous than someone just having arms. I think that that's like the kind of argument that you would expect to be made after this case, because you can't have a more loose inference that's not really explained, where the government just says no more, you can't get more than one gun in 30 days, and that's kind of it. I think they would have to do more work in showing data on, when we've looked at people stockpiling weapons in a 30-day period, there are dangers associated with that, and we have all these reasons for thinking that. And at least they would have some kind of ground to stand on empirically. But unless they have that information, it's just an inference that's not based on much. And I think the same thing goes for whether it's a uniquely dangerous person or not. It may be true that there is evidence out there that the government could have marshaled showing that someone who is going and starting to stockpile weapons, buying a bunch of them in a 30-day period, I wouldn't be surprised if there are some people that they might be able to show are doing that for reasons that concern them. But the problem is, until you have some kind of evidence for that, you are just sweeping in a bunch of people who are exercising their rights responsibly and just happen to be buying more than one gun in a month. And so that to me is where there's the law seems to reflect those inferences, but it doesn't have any evidence to support them. And they didn't really seem to make those arguments very clearly. So I could imagine a case that's harder, where they're making those points, even if this history and tradition is the same. And I think that would be a harder case. I'm not sure that would come out differently. And I think that the Ninth Circuit actually did a really good job with analogizing it here. Though I think that the question of what level of generality obviously will continue to be a problem, and I could very easily imagine a different Ninth Circuit panel getting this and having a completely different view of the level of generality, and even looking at some of these examples that the court cites here and saying that's sufficient under Bruin, and we're going to allow the law to stand. So, I do think that this is a unicorn. I also think that it's probably right.
Yeah, it does seem like the lack of an analogy, anything close to an analogy here really dooms this under any fair application of Brahimi, as David Latt has called those two cases combined, because there's just not, like, once a month, there's just nothing in the history about that. Now, I want to go back, though, to the once a month law that I most hate, which is the one Sudafed a month. So, and we can get into a little bit of the analogy of rights that you were playing up. So, of course, there's no enumerated right to, like, buy medicine, but so I guess we could say that's a rational basis case because it's unenumerated, non-fundamental right or whatever. It seems pretty important to me to get medicine, but really what's going on there, right, is that the government's trying to go after the making of meth, and if you can only buy these packages a month, then you're just not going to get enough unless you wait years to make a lot of meth, and so that cuts down on the meth dealing. And really, if you need it just for, like, your household, you can get by unless you're sick 24/7. You can get by on one Sudafed a month. Like, sometimes I will buy a thing of Sudafed or generic whatever when I'm at the pharmacy when I totally don't need it, but I'm like, I haven't done it yet this month. I better go do it and stockpile.
Why are you stockpiling Sudafed?
Because everyone in the family is sick frequently. And so we need, like, there is a constant need for Sudafed around the house with 4 of us who often need it. So Anyway, and like you get a cold, you could go through a box of Sudafed in a week because it lasts 12 hours. It actually dries up, unlike that fake stuff that when this thing came in that they marketed and everyone realizes now it's like totally bogus, so it doesn't do the PE kind or whatever it is. Anyway, I'm get off my Sudafed box here in a minute, but you can work around it, right? For the purpose of just getting medicine. Whereas getting one gun a month, now maybe it's doomed anyway because there's just no analogy. But if we get into kind of more like ends means fit, if you maybe at like 5 guns a month, 12 guns a year, because I'm guessing like if you're buying guns and it's not to give to other people, it's like, oh, hunting season's coming up. I want to go get a couple of rifles. Or, my wife and I are thinking of taking firearms training because whatever, we're each going to get a couple of handguns. And so it's not like every month you're going to buy lots of guns, but one month you very well might buy more than one gun. And so it's just not a fit. But I could see, if they come up with, 5 a month or 12 a year, 14 a year, I don't know, then you're probably going to be much more in the box. Now, it's still not an analogy, so maybe that's doomed anyway, but I could see, the Ninth Circuit being more okay with that.
So I take all the points, and I just have to say, it sounds like either A, everyone in your household was sick like 2 weeks ago and you're really focused on it, and B, that you've got like an illicit stockpiling and straw purchase Sudafed ring going on in your house, and I'm really concerned.
I'd love to say if you want Sudafed, come to our house. But
no,
the thing
literally don't say that.
We barely have any around because we use it all.
Okay, so I take both of your points. I genuinely do, and I do think you can have a shorthand for people who are buying a bunch of guns and say like, well, that's odd and that's unusually dangerous. And I also take the point of, is there ever some sort of like limit for what's rational for number of people can have? And I analogize it to a lot of our other constitutional litigation. You can make the assumption that maybe people who buy 3 guns in a month or whatever number you want to create are dangerous. What I'd like to see before the government starts to restrict people's rights is evidence. I want to see that they are acting, that they're not just acting on assumptions, that they are looking at data and thinking, this is a problem that I can specifically identify for 1, 2, 3, 4 reasons, and this is a not overly restrictive means of addressing it. What we have here is completely divorced from that. We just don't have any evidence. And to be fair, that's more of a tier of scrutiny issue. We deal with it in our economic liberty cases all the time, rational basis versus strict scrutiny. And I don't know how it would apply to text, history, and tradition. But I also take, Anthony, your point about like, is there some sort of number that's just nuts? And look, I think you could probably tell my priors. I do believe in a strong Second Amendment. Others may disagree with me. This is a hobby for people, for law-abiding people. People like to purchase differently modified versions of them. They like to go firearms shooting. I have friends with, honestly, a little bit scarily large arsenals, but they themselves are not scary. They are law-abiding individuals. This is ultimately an enumerated right. It is the second right listed in the Constitution, and as it talked about with that paragraph I quoted about we wouldn't restrict people's free speech rights if you're going protesting every day, like that's a lot, that this isn't the redheaded stepchild of Bill of Rights. This is an enumerated right, and if the government's going to restrict it, they either A, have to have evidence that you are specifically, that a person is violating or is unusually dangerous, or at least evidence that like the means ends fit goes together. And I will say there was one other historical analog that I thought was useful. And again, this is the technology change. Back in the 1800s, people used to carry, according to the decision, six pistols with them. They were sold in pairs because you couldn't reload them as easily. They were single shot. Granted, weapons have much greater capability now. But historically, people were allowed to have multiples. And the founding generation was not like unaware of the ills of arms trafficking. Arms trafficking has existed going back as far as arms have existed. And what you try to do is criminalize criminal conduct and criminals. You don't try to restrict the behavior of law-abiding citizens, even if, admittedly, like there is a number of guns that if you see, it's like, well, that's a lot.
Yeah, one of the things that in comparing it to other rights, which I did love that in the opinion, and I think that the actual language that the court uses something like we don't allow the metering of constitutional rights, which I thought was very good. And when I read that initially, I was like, okay, I like that comparison, but how much is the Second Amendment like other rights in that regard? But I think if you put yourself back in the place of like the early U.S. Supreme Court decisions about the First Amendment, where they're very scared of anti-war protesting, they're very scared of communism. They viewed those things as directly potentially dangerous and chaotic. And I think it is easier to actually make that comparison the court wants to make. It's not just that we don't want to have other constitutional rights metered out. It's that the exercise of other constitutional rights do often come with risks, and despite that, we require the government to come up with evidence when they're going to restrict it. And in that way, it seems like Brahimi is doing exactly what the court wanted it to do in the context of the Second Amendment, which is to kind of stop courts from treating Second Amendment claims under something that's like a conceivable basis version of rational basis review. And the Ninth Circuit at least seems to have got that message.
Yeah, I think that's the bottom line for this case is it would be nice if the government has evidence. And when you take a step back, it is kind of shocking that they really don't have any for this law in this case. I was thinking one other thing where someone very legitimately non-scary way could run afoul of this law is if you went to an auction and bought a few guns at the auction, right? I think that happens. I don't go to those kinds of auctions, but that happens all the time. I don't go to many auctions at all, by the way. It's not like I hang out at Sotheby's. But does Sotheby's have gun auctions?
That's shocking, actually.
I kind of doubt it.
I could see you as an auction dude, especially if they sold Sudafed.
I have family members who love going to like painting auctions, that kind of thing. But we'll talk about that.
We have an IJer who really loves auctions.
Oh, yeah? Oh. We should get an auction case sometime. I think we might have a few years ago. There was some like illicit art trade type thing we talked about. But there's another illicit trade, and that's baby's blood. Not really a trade, more just stealing. But it's going on in Ohio. So, well, not quite like it used to. And I am very confused by that. And John is here to unconfuse me and sort out what's going on in the Sixth Circuit in Kanuszewski. My Polish is not perfect.
I think it's Kanuszewski.
Kanuszewski. There you go.
That is impressive.
That's what we're going to go with, Kanuszewski.
Sorry, and I said Ohio, as it's in Michigan Department of Health and Human Services.
Yeah, so this is like Anthony said, this is a Sixth Circuit decision, but we're actually going to talk a little bit about two Sixth Circuit decisions in this same case. So this most recent one was in June of 2025. It was very recent. And this case is about Michigan's newborn screening program, and it's existed since the mid-1960s. And what it essentially consists of is whenever a baby is born, someone who works for the Michigan Department of Health and Human Services, they prick the baby's heel, they take blood samples, usually 5 or 6 blood spots, on these pieces of paper that they call blood spot cards. And what they do with those blood spot cards is they then run it through an initial screening process to look for diseases and things like that. And they do that within hours of birth. And those cards also contain demographic information from the baby and the mother. But they don't just throw the blood cards away. So what they do is they used to take, before 2010, the department would take those cards and they would store them in their own laboratory. And what they started doing after 2010 is they would actually get rid of most of the cards. They would keep one, and they would put the card in a nonprofit corporation's biobank. And so they kind of use them as a temperature-controlled storage facility. And what they did when they would transfer that one card that they had retained is they would remove any identifying information. So the card that was retained would have just a list of like 8 digits on it. And they would give that card to the biobank. The biobank would store that in its temperature-controlled facility. But the department, in its own electronic records, would keep the identifying information that matched up with those 8 digits. And so what that meant in practice is that if you want to know whose blood is on the card that's at the biobank, you could match it up by going to the identifying information that the department had in its electronic database. So the department can keep those cards, the cards with the baby's blood on it, for 100 years, which in this case they said that they were intending to do. The
Wow.
biobank was intending to do
How
that
could
as
like a
well.
nonprofit promise to do something for 100 years? That just strikes me as a little science
Yeah,
fiction-y, but anyway.
Yeah, no, it is quite strange, and there's a state law, I think, that sets the limit on how long the department can keep those, and it sounds like that same 100-year limit applies to the biobank as well. And the court made clear in its most recent decision that both of those entities intend on doing that. So one question is, why would you even have these cards being stored in the first place, right? You've gotten the heel prick, you've run the initial screening, you've looked for these diseases. And so why would you have these cards end up at the biobank? And that's because there's essentially 3 things that Michigan wants to be able to potentially do after the reason they want to retain them. And the first is that they say that they use them to validate the screening tests, and essentially to calibrate the testing instruments and methods. Though, as the district court pointed out in this case, they use basically the same 5 samples to do that. So the idea that you need all of these, it's not really true. So the second reason that they say that they keep them is because they allow third parties to access the anonymous samples for medical and public health research. So they engage in transactions with people who are doing like public health research. And so, I mean, it's a useful way to kind of do large scale public health research on all these people's children's blood. And then the third thing is to do crime victim identification. And so how that works is the family can either give their permission for the blood spot to be used for crime victim identification, or the government can obtain the identifying information and the blood with a warrant or a subpoena.
And is it, they only say crime victim identification, not crime perpetrator identification?
Right. Though I can't see how, practically speaking, that actual line would be policed. I don't know what the actual use is on the back end. Part of the thing that's going on in this case is that the government didn't use the plaintiff's children's blood for those purposes, so we don't really have it's not a situation where someone is saying you shouldn't have used my blood and my blood is what allowed you to put me in prison. It's not one of those situations. So the problem with all of that, the blood prick, the screening, the retention, the storage, the subsequent uses, is that the department doesn't obtain parental consent for any of it. At no stage in that do they ask the parents whether they are okay with it, whether they're interested in doing it. And after 2010, the department does now ask for parental consent to use the blood for research purposes. So one of the 3 reasons why they store and retain it. They do not ask for consent for any of the other reasons: the heel prick, the initial screening, crime victim identification, or the validating screening test. And so a handful of parents whose children had their blood taken, screened, stored, and now are sitting in the biobank in these blood spot cards, they sued the department and the biobank, and they argued that the collection, screening, storage, and subsequent use without parental consent violates their own and their children's right to substantive due process under the 14th Amendment, and were unconstitutional searches and seizures under the 4th Amendment. And so this gets up to the 6th Circuit the first time in, I believe it's 2019. And so this is in Kanuszewski, we can call it Kanuszewski 1. And the judges on that panel, and I'll just name them because the second panel won't have a single one of the same judges on it.
That's kind of important, it turns out.
Which it turns out it actually kind of matters whether you whether you like the first panel decision or the second one. So the first panel has judges Clay, Rogers, and Merritt on it. And when it gets to the Sixth Circuit this first time, it's at the motion to dismiss stage. So all the facts have to be taken as true, and that's the assumption that the court is operating under. And at the district court, the plaintiffs had lost at the motion to dismiss stage. So they appeal, and this gets up to the Sixth Circuit for the first time. And on the substantive due process claim, the court says there is a fundamental right at stake. It's the parents' right to direct the upbringing of their children, and that includes their right to direct medical care treatment. And so that's a legal conclusion. It's basically that on these facts, if these facts are true, that right is not only implicated but violated. So there's a quote from the opinion that's pretty explicit about this. The quote is, "Defendants' actions constitute a denial of the parents' fundamental right to direct the medical care of their children, and their actions must survive strict scrutiny." And that is based on the assumption that they are, in fact, taking the blood, storing it, and retaining it without consent. That's the only facts that are assumed for it to reach that legal conclusion. And so that's what survives in terms of the substantive due process claim. It's about the parents' right, and it's not going to be about the initial screening. It's going to just be about storage, retention, and subsequent uses. And so they remand that for factual discovery. And in discovery, this first panel says the things that are going to matter is, did the parents actually consent? Does the government have a compelling interest? Things like that. It's not going to be whether there's a fundamental right at stake, because the court has already made that conclusion. And so on the Fourth Amendment claim, the court this is still the first panel, whittles it down to a unlawful seizure claim. And the panel says, again, if these facts are true, and they say, quote, "If this is indeed defendant's purpose in retaining the children's blood samples, then their ongoing indefinite seizure of the samples is unreasonable." And so they're saying if the government is doing what the plaintiffs say that they're doing, this is unconstitutional under the Fourth Amendment. And so they also send that back down for discovery to either prove or disprove those facts. So it goes back down to the district court following discovery. The district court takes those legal standards that the first panel had established, applies the facts to them, and rules for the plaintiffs this time. So now the defendants appeal, and this is where we get this most recent decision. It goes back up to the Sixth Circuit. This is Kanuszewski 2, and we have a totally different new set of judges. This is now Judges Griffin, Nalbandian, and Mathis. And so the panel starts by deciding what, if anything, of the prior panel's decision it's bound under. And so you can kind of tell starting off that the second panel is kind of saying, what of this do we actually have to apply? And it decides not a whole lot. Yeah. And so starting with substantive due process, remember the question here after the first panel decision was whether the parents' fundamental right to direct the upbringing of their children, specifically their medical care, is violated by the department's non-consensual storage, retention, and subsequent uses of their children's blood. And this second panel's reframing of that right really kills two birds with one stone. So first, they define the right really narrowly. They say, this actually doesn't look much like the right to make medical decisions that impact your child's bodily integrity. And so with that redefinition, it's not just a more general right to direct the upbringing of your children, and that kind of includes like how they interact with the medical world, what is done with their medical information. It's really about, are you making a decision about how they're being treated is much right. more like, are they receiving life-saving care or not?
Because usually the context where this comes up, right, is like, can you pull the plug on the child kind of thing, you know, that kind of situation. And so this panel, it seems, just think that's just totally different.
Right. And they're basically saying like those cases where it's about something like whether you receive life-giving care or not is basically the limit to what the right means. And so they've kind of started with a very narrow framing of that right, even though that information, their children's blood, was taken without consent as being given in transactions to third parties and is potentially being used for criminal investigatory stuff. That doesn't really factor in to how they frame the right. So with the right defined that way, they can do two things. And this is then what the panel does with the substantive due process analysis. They say, first, if the right is really just about your ability to make medical decisions about things that impact your child's bodily integrity, well, the first panel didn't really get into that. And the first panel didn't do an analysis of how each of these things, storage, retention, subsequent uses, impacts the right as narrowly defined. Therefore, we're not bound by what the first panel said about any of that. And then second, the court says that as a consequence, no right is implicated. So storing, retaining, sharing anonymized information, it does not interfere with a medical decision that impacts your child's bodily integrity because, the blood card is in some biobank. It's being shared with someone else, maybe. It's being used for law enforcement purposes, maybe. But that isn't impacting like whether your child receives certain care or how they receive it or things like that. And so with the right narrowly defined, it just nixes really the substantive due process claim. And then on the Fourth Amendment claim, which, remember, is at this point about whether the storage, retention, and subsequent uses are an unreasonable seizure. There is no surviving search claim, so it's just about the seizure claim. And the court says that claim also fails, and what the panel says is a seizure can only occur when you have some kind of property interest, possessory interest, a legally cognizable interest in the thing that's being seized and what's being seized. And to identify whether that interest exists, we look to state law. And there's nothing in state law that gives you a right to your anonymized blood sample that has been taken without your consent. They don't tack on that last part. That's definitely me. But they do say you don't have a right in an anonymized blood sample. And so that's the level of, speaking of levels of generality, that's the level of generality that they're looking at this question of whether you have a right in it. And then they say, and actually, on the other hand, there's actually evidence that you don't have such a right. And what's the evidence for that? Well, the fact that they're allowed to take this in the first place legally.
Because, who has a right to their own body? Like, no one's ever claimed that.
Right. And that's kind of the problem here is that blood, it was a problem for this most recent panel, but it clearly wasn't a problem for the first panel, is that there's a difference between maybe drawing blood immediately. That seems to be the distinction that the second panel is drawing, because they cite this case called Skinner, which does talk about how drawing blood implicates all these different issues. But the problem is that blood has then been taken and it's been put in a biobank on this card, and now really is it yours or not? And one of the strangest things about this analysis is, as I mentioned before, post-2010, you can actually, and I believe I mentioned this, if I didn't, it matters, you can actually contact the department as a parent of a child whose blood is being stored or as a child who has become an adult, and you can tell them to destroy your blood sample. Now that's quite interesting if you're going to say that there is no kind of cognizable interest at all, because that law is allowing you to control how the sample is being used. You can have it destroyed. I don't know of many situations where someone doesn't have a right in something that they can have it destroyed. It's quite unusual. And so the panel just kind of waves that away. And there's a couple pretty interesting takeaways, not only in terms of the court's analysis, but the relationship between these two panel decisions. Because if you think back to what this first panel had said about both substantive due process and Fourth Amendment. So on substantive due process, they had said if it's true that the defendant stores and retains and uses this blood, as the plaintiffs say, those actions constitute a denial of a fundamental right. That's a pretty explicit statement. It's a legal conclusion that is based on an assumed set of facts, and those facts didn't change by the time it got to motion for summary judgment and to the second panel. And so the thing that happened with Fourth Amendment is kind of similar here, is the prior panel had said, if this is indeed the government's purpose for retaining the blood, the ongoing use is unconstitutional. It's an unconstitutional seizure. Again, another legal conclusion that's based on an assumed set of facts that did not change by the time it got to MSJ. So what happened between the first panel and the second panel? And I think what's going on here is just the second panel looked back at the first panel and said, and I would have reached a different conclusion about this. And it took a very smart, subtle path to getting around the first panel's conclusions, because they were conclusions. I mean, they were legal conclusions about the relevant standards. And it did that in a way that it could reach what the second panel thought were the right conclusions. And on the substantive due process claim, the way that it did that was by narrowly defining the fundamental right. And then on the Fourth Amendment claim, it primarily did that by finding that there was no possessory interest. But neither of those conclusions are consistent with the first panel's decision. And what I mean by that is, if the second panel is correct, then the first panel is wrong. Not about the facts, but about which legal standard applies in identifying the fundamental right and in which legal standard exists for identifying the possessory interest. Because if the fundamental right was as narrow as the second panel said, this should have been affirmed by the first panel and all these claims should be gone. And if there was no possessory interest, the first panel's conclusion about the seizure doesn't make any sense. And so I think what you have is two panels who fundamentally disagree with each other about those legal standards, not about how those standards apply to particular facts. And that, to me, seems like a pretty good candidate for en banc review.
Will, does all this seem like a problem to you?
Yeah. So honestly, John's legal analysis is spot on. There's nothing I can add. But I do have two takeaways, and I kind of want to focus on the lawyering aspects of it. I've been practicing law for 16 years. I've done a lot of different areas before I came to IJ. And just I'm not trying to be dramatic when I say that what happened here is my absolute worst nightmare. This literally, I've woken up in the middle of the night, terrified that this type of thing will happen to me. You file a case, you write up a complaint, you put in a ton of work to frame your arguments as well as you possibly can and to put in everything that's important into your complaint. In this case, you get dismissed on a motion to dismiss, saying that it's not viable, it's not a plausible claim. You win on appeal and you go back down and you prove it. I'm a trial lawyer. That is what I do. This case is there was a bench trial. They proved that everything they wrote in the complaint was in fact true. They are holding this blood for basically research and to do crime investigation later. And then you get on appeal and it's a different panel, or even if it's the same, it doesn't matter. And they start to slice the right really thin. So for Fourth Amendment, the search involves privacy, but the seizure, the holding of the blood only involves a possessory interest. And then at the very end of the complaint, they say that we don't actually even need to resolve this important question because the plaintiffs failed to prove their claim. At no point in their complaint, however many years backwards, did they allege the magic words that they had a possessory interest in the joke you made, their own body. The idea that I've done a case for a decade, I've done a trial, and then just later on it turns out that my complaint missed magic words is literally something I have woken up in the middle of the night about. And so that's takeaway number one for me.
It's happened to me. I'll share that story in a minute, but yeah. Not just in the middle of the night.
Yeah, I think we all do. If you're not waking up in the middle of the night freaking out that you've screwed something up, you are not a lawyer. Don't go to law school. So my other sort of takeaway is, and I kind of hate to say this, and I wasn't really sure if I wanted to, but it's frustrating just how many things kind of turn out to the luck of the draw. As I said, I practiced a lot of different areas of law. My sort of background is criminal defense, and we talk a lot about conservative or liberal justices who appointed Supreme Court justices, but judges are people. and they have priors, just like I had priors about dealing with the Ninth Circuit case earlier. And just, they have different, I don't want to use the word bias, but they have different like viewpoints in the world. They have different things that are important to them. And it is frustrating to me how much one panel can completely agree that this is a fundamental right. The next panel just say like, well, you didn't even plead that it was possessory, and we've chopped it into several different pieces. And just luck of the draw. It's frustrating.
Yeah. Yeah. What I keep going back to is this: the panel says it's not bound by the law of the case, which is this doctrine that usually comes up with successive appeals, that the court has to follow what it said prior. Sometimes a trial court, same thing. But I don't even see this as law of the case. This is just like precedent. There was a panel decision. It was published. That is binding on future panels unless you go en banc. And it happens to be the same people, but it's still precedent. So John, you read this more carefully than I do. Is there some exception to precedent when it's the same parties? I mean, I haven't really thought about this before, but it just
actually
doesn't make sense.
It's called the "I would have done this differently" exception, and it is. I mean, that's why the second panel is kind of it's very interesting as a study of how you could look back at the prior panel. You could find points in it that are maybe inferential and maybe not as spelled out, and then you can use those as kind of weak points, where you can say, well, if they would have gone further into that analysis, it's not that they're wrong legally. It's just that they didn't go into that analysis, and if they would have come out differently. And so you can kind of do that in a way. And to be fair, you could look at the first panel and say, they could have gone into more detail about the nature of some of these rights. Maybe they could have gone into more detail about what they thought the possessory interest was. But what you can't say, and this is like why what Anthony's saying is such a problem in terms of precedent, is the first panel did say that if there is a fundamental right, they described the scope of that right, and then said if the facts land within that scope, there's a constitutional problem and strict scrutiny applies. And the same thing with the Fourth Amendment claim. They weren't saying, well, if there's a possessory interest, this or not. They repeatedly referred to it as the child's blood, and they weren't saying that was the question. They're saying on remand the question was, are these actually the government's purposes for retaining it? Because if they are, this is a constitutional violation. And so I think that it's a way, the second panel really is weakening or kind of framing the first panel's analysis in a way that makes it sound vague. And really what they're doing, and you can see this even in the section where they're talking about law of the case, is they cite a lot of cases where there's like dicta in an earlier panel decision, or there's kind of vague discussions about the facts. And what they're doing is they're kind of using that to, in many ways, disassemble the first panel opinion, even the legal conclusions of it. And so I agree. It is precedential. There are conclusions in here that you can just have a simple thought experiment, which is, if you got the first panel decision and you had the same judges and you got the second panel decision, would you think that the judges were schizophrenic or that they had forgotten their panel decision, right? Like that, it's that jarring. And so like Will was saying, you end up with this kind of unfortunate, like, acknowledgement that you depending on the panel you get, sometimes you get different conclusions, and you might even get a panel that says that what they did before was actually not what they did before, and it seems like that's what's going on.
So quickly before we end, so my war story I was alluding to earlier was we litigated a case here at IJ all the way up to the Minnesota Supreme Court, and we averred in our complaint that we were bringing, it was like we brought it under a bunch of other stuff too, but under this clause in the Minnesota Constitution that's a right to a remedy clause, because it was a constitutional claim. So the case gets all the way to the Minnesota Supreme Court. We're arguing that we brought it under this clause, and that the case was otherwise moot, but that we had a damages claim. And the court says, well, you didn't specifically say anything more than just, this is kind of a novel cause of action. You didn't say anything more than just averring it in the complaint. And we're going to say that you didn't address it below. In the complaint, right? And this is right after the court, just a few months before, had rejected the Twombly and Iqbal cases and said that we just have notice pleading. Like, complaints are super, super broad. All you have to say is a bunch of facts. You don't even exactly have to say the cause of action. And yet when it came to this, they said, oh, you didn't exactly plead that in the complaint. And like, the two don't go together. So what was going on? Well, they didn't want to address our claim is what was going on. But not that I'm bitter.
That's how Iqbal works. It's notice pleading, but not for constitutional cases.
Right.
Doesn't apply to our cases.
And I guess what I should say more there is that case went to summary judgment, and this case we're talking about today is summary judgment. By the time you're at summary judgment, the Supreme Court has said, and definitely when you get to trial, or I'm sorry, they did have a bit of a bench trial.
This was a bench trial
on the Fourth Amendment claim. Yeah, is that the complaint shouldn't matter at that point, right? That's just to start things out. And so when you see the complaint come up on appeal, it just seems to me there's often something funny going on. We should end by saying, John, so Michigan has changed the law though since this case was brought, right? So the things are a little better if you're from the privacy standpoint now.
It's true. There's actually been a consent decree as a result of this case. And so that was actually part of the discussion at this the second panel about whether certain claims were moot or not, and the court decided that they are not moot, and that's what allowed them to answer this on the merits. And I should also note that IJ is currently in the early stages of litigating a challenge to New Jersey's practice of taking blood, children's blood without their parents' consent. And there's not overlap here outside of the fact that it's kind of in a similar kind of issue. But if you're interested in this issue, that's something you should kind of keep your eyes out for, because this is not the only place where this is happening in the country.
That's right. It's common practice, and it is, especially in our age of DNA and data banks and all that. It's a little different than the 1960s when you just keep a blood smear in a library somewhere. But thank you both for coming on. This has been a great conversation. Thanks everyone for listening. Please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.